a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, and given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yanetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from...
No, I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed... So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motions.
That's fine. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, you know, Your Honor, I'm getting to that in terms of
right, so go ahead. You have your remarks.
That we're either required to give them or not. You know, it is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, but in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, that's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I don't know if they realize this, but that was my case. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial. This, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial.